The only narrow question which remains to be answered is whether any person who has been charged with the same offence, with the co-accused is charged, but which is not an offence specified in the section 3, can he be tried with the co-accused at the same time by the special judge? We are of the view that since 4.3 of the Act, which I showed you also, authorizes a special judge to try an offence other than the offence specified in section 3, the provisions of so and so apply. There is no reason why the provisions of 223 are not applied. 223 in clear terms provide that persons accused of same offence committed in the course of same transaction, or persons accused of different offences committed in the course of same transaction may be charged and tried together. Applying the provisions of section 3 and 4 of the Act, read with so and so of CRPC, it must be held that the appellant and his co-accused will be tried by the special judge in the same trial. This is because the co-accused and the appellant who have been charged in the offences of section 3 must be tried by the special judge, who by virtue of the provisions of section 4.3 and so may also try them of the charge under 120B at the law 20. Now, look at this really carefully. Forget the fact of the third fellow. This is because the co-accused. Look at it again. The appellant below was not charged with the PCI, the other two were. Now look at this again. This is because the co-accused who have been charged with offences under 3 must be tried by the special judge. Also in view of 4.3, may also try them of the charge under 120 read with 420. Therefore, all the 3, including the appellant, have been charged of the offence under 120, 120. If the special judge had jurisdiction to try the other 2 co-accused for offences under 120, provisions also attacked. Therefore, it follows that the appellant is also charged with the same offence, same direction. He also will tried. Otherwise, it will be informed us that some of the conspirators of having charged of having committed the same offence may be tried by the special judge, while the remaining who are also charged the same offence will be tried by the other. That's the ultimate rationale. Because the moment you split, this is what will happen.
No disagreements with that proposal.
The split will create this problem. So this will create this problem. And in any case, look at our situation. We are at the initial stage. It's only an FIR, there is no trial, there is no case. There is no judge. Look at the stage at which we are. We are today actually 5 days of adding somebody as an accused and 482 is filed. For quashing an FIR, we are looking at an FIR. We are not looking at the court. The court has not stepped in. Court has not done anything. Cognizance is not there. Charging. We are talking about a situation which may arise. God knows when. Today it's a simple case. Case FIR, which says PC, non-PC, for PC, people and private people. That's where we are today. Why should we talk about issues which don't arise? We are at a very nascent or at the first steps.
The time in India.
So 240.
Okay.
If not a decision after a trial, what has happened in the charge, whether he is discharged, not discharged, none of those issues arise. Very simple issue arises. Does the FIR make out a cognizable offence? If it does not, will question. If it does, on the test of Bhajan Lal, Bhajan Lal is the test.
No, because here primarily 17A was argued.
Correct.
And what we are looking at is, in the event the succeed
This happens, that happens.
then
At the end of the day, the argument, one line argument of mine will at the end of the day is, please look at the FIR. Does the FIR make out an offence or not? Test of Bhajan Lal is read the FIR. If a cognizable offence is made out, that's the end of the matter. Everything else is in trial, including this fact, this is discharge of duty, not duty, all that is there. This is we are actually going all over the place, if I may say so, for no real reason. For no real reason. All that will happen when investigation is complete. Somebody gives a charge sheet, the judge exercises jurisdiction, looks at it, and then takes a call. All that is different. Then it is in season of the trial. The trial court will decide something, the appellate court will decide something, civil court will decide something. But there are today. They will not say the date, not even that. Added on 7th or 9th of September, and in 5 days this was filed. That's not the long and short of this. Ultimately, it's good to have an academic debate, but this is not a case of a stage to have that debate. needs to have that debate. And see one more thing. The same police authority investigates PC and non-PC. It's not that there are two things here. The same police here, the state police, is investigating PC and non-PC. It's not as if that there is some difference in the investigation. There is no difference in that investigation. Then how will the FIR be quashed? Ask myself, with the same police, to launch an FIR under 10 IPC sections and say 2 PCR sections. And I gave a also to a judgment that in PC Act, which was available then C and D, you can register today in regard to that. That is settled. No issue.
The 13(1) C.
Yeah, that's right. That is settled. 13(1) C and D will apply to the facts which were then prevailing when 17 C and D were of the statute book. In fact, have a look at section 5 also. Give some insight, on the privacy of this corruption code. Section 5. Because the Lordship finds, this is a special act. There are special provisions. 5. Most of these provisions are notwithstanding CRPC. 5. A special judge may take cognizance of offences without the accused having been committed to it. Without committal. Even in a murder case, you are first before the magistrate. The magistrate commits to the sessions and you go here. Even without committal, he can do it and he can follow the warrant procedure. It is only to show it's a special act. It has been given primacy like PMLA, TADA, etc. And in that primacy, it takes away the jurisdiction normally of that non-PC cases and brings it to it. So that will not be legislative, but we don't need to go. None of that has happened. None of that has happened. As and when it happens, people will raise the issues whatever to us. Not here. But I will join the Lordship's attention to the counter affidavit filed in the High Court to show a Lordship what is the flavor of this case. No case can be argued on law unless you have some background on what the case is. You are ultimately wanting to quash an FIR. The FIR is based not prima facie on these cases.
That you had argued that day that these shell companies were formed and
correct. All that is here. And I also refresh your memory. There is income tax investigation. There is GST investigation.
various agencies.
There is SEBI investigation. So to say it's a vendetta by the state is absolutely wrong. FIR of 21, I would have arrested him on day 1. In 21, he is added in 23. And meanwhile, those 4 agencies are going on. 4, there is a forensic also, it is shocking if you not read the counter. Even read the counter, it is shocking how the bureaucrats are overridden by the person concerned. Override, pay. To pay 370 crores. Bureaucrats say no, 5 notices I have attached. This is not a frivolous case of somebody just trying to grab somebody's collar. So after a period of 2 years, and all these material surfaces, we have added it. We did not add it in 2021. We added it in 23. The GO, I told you also, the GO said that those 2 private bodies will pay 90% for the expenditure of skill center, we will give 10%. Then the agreement is made that 90-10 is gone. And our people paid 370 crores to those 2 companies, which went to shell companies, which ultimately went to display all this here.
Anyway, actually, the Bhajanlal clause to it has not been argued. It has been argued only on 17A.
I agree. I am only saying, I am showing it for another reason. This is the reason why this court should refuse, or a 482 court should refuse to exercise jurisdiction. I am on a slightly different point. 482 is discretionary. 136 is equally discretionary. In 482 or 227 or 136, your lordships have discretion. It's not a suit for possession in which there is no discretion of the court. These are discretionary. Discretionary relief. If discretionary reliefs are there, there are, my lord, ways and means to decide how your lordship will exercise discretion. Person who comes with unclean hand, person who suppresses, all those are principles of, my lord,
All
discretion.
discretion has to be decided judicious.
Judicial. If your lordship's discretion is, my lord, is shown that these are the facts, put your lordship's judicial discretion or judicial mind, my lord, go in favor of a person who is, my lord, prima facie guilty on affidavit. Then I find, my lord, in affidavit all these details.